Speaker, and indeed I do rise on a question of privilege for which I gave notice earlier this same day. Mr. Speaker, I rise on a question of privilege regarding the conduct of the member for St. Catharines, who attempted to intimidate Scott Benzie, a witness appearing before a committee of the Senate studying Bill C-11, an act to amend the Broadcasting Act and to make related and consequential amendments to other acts, as reported yesterday by the Globe and Mail. While I appreciate that this attempt to intimidate relates to the proceedings of a Senate committee currently studying Bill C-11, the culprit in this case is a member of the House, and that same witness appeared before the House of Commons Standing Committee on Canadian Heritage during its deliberations on Bill C-11. An appearance where Mr. Benzie no doubt first established himself as an undesirable witness for the government on the merits of Bill C-11. Normally, it is members who bring to the attention of a committee of the House the matter of outside actors intimidating witnesses before committee. But this case is unique in that it is a member of the House of Commons doing the intimidating in another jurisdiction, the Senate. In addition, it relates to a bill for which I have responsibilities as Shadow Minister for Canadian Heritage that had originated in the House of Commons and is now before the Senate. While this type of offence may not fall within one of the specifically defined categories of privilege, the category of contempt allows the House to deal with the unorthodox nature of this case. Pages 81 to 82 of Boskin Gagnon state, quote, "Throughout the Commonwealth, most procedural authorities hold that contempts, as opposed to privileges, cannot be enumerated or categorized. Speaker Sauvé explained in a 1980 ruling, while our privileges are defined, contempt of the House has no limits. When new ways are found to interfere with our proceedings, so too will the House, in appropriate cases, be able to find that a contempt of the House has occurred." End quote. Another perspective of parliamentary privilege is the notion that behaviour of members fall within the exclusive jurisdiction of this House. At pages 181 to 183 of Manjoy's Parliamentary Privilege in Canada, it clearly states that the Commons' jurisdictions over its members is absolute and exclusive, whereby the House has the power to enforce discipline on members of the House of Commons. Page 76 of Boskin Gagnon refers to one of the rights of the House recognized by the Supreme Court, that is, the disciplinary authority over its members. The next question is why the House exercises its disciplinary authority over a member in this case. Simply put, what's good for the goose is good for the gander. Attempts by anyone to intimidate a witness before a committee is considered a contempt. It is particularly offensive that it is a member of this House who is attempting to interfere with the work of a committee in a manner that would be considered a contempt had it been attempted by a member of the public. In the Globe and Mail story I referred to earlier, it reports, quote, "A Liberal MP has asked the Lobbying Commissioner to investigate an outspoken critic of the federal government's online streaming bill for failing to immediately disclose funding from YouTube and TikTok. The Heritage Minister's Parliamentary Secretary asked Lobbying Commissioner Nancy Bélanger to launch an investigation into Digital First Canada, an organization that advocates for YouTubers and people posting videos on platforms. Scott Benzie, who's the Executive Director, questioned the motivation of the Minister's Parliamentary Secretary in referring him to the Lobbying Commissioner. He said that the MP had not asked for a probe into organizations receiving outside funding, both public and private, that had given evidence in favour of Bill C-11. Mr. Benzie said that he was speaking out about the bill because no other group was representing the views of individuals posting videos on YouTube, including creators making $16 a month, and that he was concerned about the impact of the legislation on their livelihoods." End quote. A similar situation occurred on December 4, 1992. The then member for Glengarry Prescott Russell rose in this House to bring to the attention of the Speaker the intimidation of a witness appearing before a committee of the House for remarks she made during testimony at that committee. The CBC threatened a lawsuit against the witness because of evidence she presented at the committee. The Speaker ruled the matter to be a prima facie question of privilege. Also noteworthy in this case is that the Speaker came to this conclusion without a report from a committee. In this case, the Parliamentary Secretary to the Minister of Canadian Heritage is threatening an investigation against a witness because of evidence he presented to a committee. Page 267 of the 24th edition of Erskine May states, quote, "Any conduct calculated to deter prospective witnesses from giving evidence before either House or a committee is a contempt, end quote. Similar statements are made at page 82 of Boskin Gagnon, which explains that witnesses are protected from threat or intimidation. Paragraph 15.23 of Erskine May 25th edition states, quote, both houses will treat the bringing of legal proceedings against any person on account of any evidence which they may have given in the course of any proceedings in the House or before one of its committees is a contempt. On April 13, 2000, the Senate Standing Committee on Privileges, Standing Rules and Orders presented its fifth report, dealing with allegations about reprisals against a witness. The report stated in part as follows, quote, the Senate and all senators view with great seriousness any allegations of possible intimidation or harassment of a witness or potential witness before a Senate committee. In order for the Senate to discharge its functions and duties properly, it must be able to call and hear from witnesses without being threatened or fearing any repercussions. Any interference with a person who has given evidence before a Senate committee or who is planning to is an interference with the Senate itself and cannot be tolerated, end quote. Mr. Speaker, our privileges are necessary to allow us to perform our duties and to defend against threats against the authority of this Parliament. The fact that this threat came from within this place is particularly distressing. Mr. Speaker, even if you have some doubts about this case involving a Senate committee and the conduct of a member of the House of Commons, I urge you to give this case the benefit of the doubt. I refer you to Mangio, second edition of Parliamentary Privilege in Canada at page 227, which I'll quote for your benefit. In the final analysis, in areas of doubt, the Speaker asks simply, does the act complained of appear at first sight to be a breach of privilege, or, to put it shortly, has the member an arguable point? If the Speaker feels any doubt on the question, he should leave it to the House. In a ruling of October 24, 1966, at page 9005 of the debates, the Speaker said, and again I quote, in considering this matter, I ask myself, what is the duty of the Speaker in cases of doubt? If we take into consideration that the moment the Speaker is not asked to render a decision as to whether or not the article complained of constitutes a breach of privilege, considering also that the Speaker is the guardian of the rules, rights and privileges of the House and its members, and that he cannot deprive them of such privileges when there is uncertainty in his mind, I think at this preliminary stage of the proceedings, the doubt which I have in my mind should be interpreted to the benefit of the member. Further, on March 27, 1969, page 853 of the debates states the following. The member has perhaps a grievance against the government in that capacity rather than in his capacity as a member of Parliament. On the other hand, honourable members know that the House has always exercised great care in attempting to protect the rights and privileges of its members. Since there is some doubt about the interpretation of the precedents in this situation, I would be inclined to resolve that doubt in favour of the honourable member. Mr. Speaker, there are ample precedents to allow you to put this matter to the House and to have it decide on the best course of action and what it might be. If you do give this matter the benefit of the doubt and find a prima facie question of privilege, I am of course prepared to move the appropriate motion. Thank you, Mr. Speaker.
First, I want to thank the member for that point. I believe we have an intervention on the same point from the Honourable Parliamentary Secretary to the Government House Leader.
Thank you very much, Mr. Speaker. Just on this point of order, we've had an opportunity to listen to this and would like to get back to you with some comments on it. So if you would be so kind as to give us a couple days to do that, it would be greatly appreciated.
Of course, the Honourable Member for Powell River, North Island, Powell River.
Well, thank you, Mr. Speaker, and I thank the member for, of course, bringing this to our attention, and the NDP reserves the right to reply. Thank you.
I believe that the Honourable Member for La Prairie would like to take the floor. Mr. Speaker, we have heard and noted what my colleague had to say, and we reserve the right to reply or to react ulteriorly. Thank you, Mr. Speaker.
Merci beaucoup.